Hello, thank you for tuning in. This is Stephanie Nicholls, the Statewide Training Manager with Michigan Alliance for Families. We are here today to talk about FAPE in the LRE and understanding your rights. Michigan Alliance for Families is totally free parent training and information provided all across the state of Michigan. All of our regional parent mentors live where they serve and know about local resources in those areas that they're able to share with families. Our goal is to improve educational services and outcomes for students with disabilities across Michigan. Please do not hesitate to reach out to your regional parent mentor with specific questions about your situation. They can be reached at 800-552-4821. Before we get started, I want to make sure that these key acronyms all make sense and you have a reference point of what they mean. We will talk about them in depth throughout the presentation, and there are more than just this handful of acronyms in today's presentation, but my intention is by the end of our time together, you're going to be familiar and comfortable with Free Appropriate Public Education, that's FAPE, Individuals with Disabilities Education Act, IDEA, Individualized Education Program, IEP, and Least Restrictive Environment, LRE. These are some of the big concepts that are in our presentation today, and I just want you to have this reference to come back to. If you are like, oh, she said FAPE in the LRE, what does that mean? Free Appropriate Public Education in the Least Restrictive Environment. Got it. One of those acronyms I just covered is IDEA, the Individuals with Disabilities Education Act. I think this has to be the starting point for our conversation today. This is the law that makes available a free appropriate public education to eligible children with disabilities throughout the nation and ensures special education and related services to those children. The IDEA governs how states and public agencies provide early intervention, special education, and related services to more than 7.5 million as of the 2021 school year eligible infants, toddlers, children, and youth with disabilities. Congress reauthorized the IDEA in 2004 and most recently amended IDEA through Public Law 114-95, the Every Student Succeeds Act, in December of 2015. The purpose of IDEA is defined to include ensuring all children with disabilities have available to them a free, appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for their future education, employment, and independent living. It is to protect student and family rights, assist agencies to provide education for children with disabilities, assisting states in developing and implementing early intervention services for babies and toddlers, ensuring educators and parents have tools needed to improve educational results for kids with disabilities, and ensure the effectiveness of efforts to educate children with disabilities. So pretty lofty purpose, pretty big intentions. So in that description of the purpose of IDEA, you heard free appropriate public education, FAPE, part of the title of our workshop today. Schools must provide eligible students with disabilities a free appropriate public education, FAPE, through programs and services. The FAPE must meet the student's unique needs and provide an educational benefit for the student. So the details of FAPE are in the acronym. So let's break it down a little bit and just start with that first letter. The F is free. That means that special education and related services are provided by public schools at no cost to the families. Schools also can't deny FAPE due to the cost of services. And it's important to remember when we're talking about free, we're talking about special education and related services. So schools can charge fees if children without disabilities are being charged the same fees. You're going to pay fees in art class for art supplies and for field trips and pay to play for sports, but there cannot be fees for special education supports and services for your child. Next is the A, and the A is appropriate. Students are entitled to an education that meets their needs. Specifically to them, it is appropriate to that one human being. And the courts have spent some decisions and some time talking about what appropriate is, and they've defined appropriate as having some educational benefit from the Hendrick-Hudson District Board of Education versus Rowley in '82. and being appropriately ambitious in light of the child's circumstances. And that's a more recent decision from Andrew F. versus Douglas County School District in 2017. So appropriate should be challenging and it should have educational benefit for the student. They're entitled to that education that meets their needs, that is appropriately ambitious and has educational benefit. The P is for public. Children receiving special education programs and related services have a right to receive an education provided by the public school system. This feels like something that currently we may feel like we don't need to say. This was something that was not an entitlement. It was not something that students with disabilities had the rights to within the public school system until the 1970s. Like, this is relatively new in the history of our society, that it is that students have the right to receive that education through the public school system. And the E is for education. And the education provided must meet the state standards and federal standards that are defined in IDEA. Every child who is eligible for special education has a right to an education, and the education should prepare all children for their future, including post-secondary education, employment, and independent living. Education is to prepare our young people for their future involvement in our society and growing into adults. I want you to be able to reference the wording that's actually listed in the federal law in IDEA. So throughout the presentation, I'll be including sections of IDEA when we're talking about those areas of the Act. So let's start with section 300.101, which addresses FAPE. It notes that a FAPE must be available to all children, including children with disabilities who have been suspended or expelled. In the federal law, FAPE starts at age 3, and the federal law provides FAPE through age 21. The federal law is the floor, not the ceiling, though. So states can do more than what's in IDEA, but they can't do less. So one thing we've done in Michigan, we've extended this range through age 25. It's also important to note that a child doesn't have to fail to be eligible for special education and related services, and that eligibility must be determined on an individual basis. I theorize that most of you have heard of IEPs. That's probably what brought you to this video. For some of you, FAPE may be a new concept. Now that you know about free appropriate public education, what do you think the purpose of an individualized education program is? Why do we have IEPs? It's actually defined in IDEA that the IEP is the offer of FAPE. It's the primary tool to deliver free, appropriate public education to our children. The IEP provides information about how your child's education is personalized to meet his or her needs, and it outlines what special education programs and related services are going to be provided to meet those needs. It also lists your child's educational goals. That document, that program, that plan provides a free, appropriate public education to our kids. This is why we create an individualized education program. That is the written plan for your child's education at school for the annual year. It should be developed for one unique child. If you removed your child's name from the document, it should still be clear that the program was developed for that one human being, for that one unique person. And it should define the special education services, related services, accommodations, and modifications for that one unique program to meet the needs of the child. The IEP is developed by the IEP Team, which brings experts together to make a plan. It's key to know that you're a member of the team. The team is not presenting the plan to you. The team is experts coming together to develop that plan, and you are an expert on your kid. You are a member of that team. At Michigan Alliance for Families, we spent a lot of time talking about the parts of the IEP, and I encourage you to check out our website, our other videos, and upcoming learning opportunities to learn more about the IEP. We are just going to touch on this today, but we do have a video on each of these sections of the IEP that you can deep dive into. We're going to continue to move through what is listed in IDEA as requirements of providing a free, appropriate public education. So Section 300.105 is assistive technology, and we must ensure that assistive technology devices or services are made available to a child with a disability if required as part of the child's special education, related services, or supplementary aids and services. So what does that mean? So assistive technology, let's start by defining that. Assistive technology, a device means any item, piece of equipment, or product system, whether it's acquired commercially off the shelf, modified, or customized, that's used to increase, maintain, or improve functional capabilities of a child with a disability. The term does not include another human or a medical device that is surgically implanted or the replacement of such a device, like a surgically implanted device. So let's think of some examples that could be assistive technology. I want to remind you it can be purchased, built, customized, high tech, low tech, or anything in between. The key is that it's used to increase, maintain, or improve the functional capabilities of a child with a disability. So it could be anything from a pencil grip to an augmentative or alternative communication device. It could be a magnifying glass or a raised line paper that gives you that tactile cue when you're supposed to have your letter go back down. Um, the sky's the limit on what this could be. It's anything that increases, maintains, or improves the functional capabilities of a child with a disability. Another piece of FAPE in IDEA that's defined is extended school year. The federal law says that extended school year services are provided to the child with a disability beyond the school year in accordance with the IEP and at no cost. So extended school year is also called ESY. ESY services must be provided only if a child's IEP team determines the services are necessary for the provision of FAPE to the child. So if it's required, if it's necessary for a free appropriate public education based on the unique needs of the child. The federal law says the school cannot limit eligibility for extended school year by disability or make a blanket limit to the type, amount, or duration of extended school year. So ESY can't be offered 3 days a week from July 1st to August 1st. That would be unilaterally limiting the amount and duration. In Michigan, we define how we're going to do that. So the federal law, again, is the floor, not the ceiling. That's the minimum of what we need to do. So in Michigan, we set those parameters of what we're going to do. In Michigan, there must be at least one current IEP annual goal where significant concern exists regarding skill maintenance during a break in services. So a student may be determined to need ESY services if one or more of these apply. And those criteria are a serious potential for regression of skills beyond a reasonable period of recoupment, the nature or severity of the disability, or critical stages or areas of learning. If there is no goal area of concern in Michigan, ESY services are not needed for a free appropriate public education. When we're considering ESY, when we're talking about ESY, that determination needs to be based on that one human being. So determination of the need for ESY services should be made on an individual basis, not from a formula or a policy. And ESY services can be provided in a variety of ways. It could be in the traditional classroom, it could be small group discussion or instruction. It could be cooperative programs with other agencies. It could be consultation with a job coach. It could be a week of intensive review just prior to the school year beginning to front load because we've seen that regression in the past. It could be home-based programs that include parent training. That this needs to be individualized in how it's delivered. Maybe it's just one service provider. Maybe we're just focusing on speech for the summer or for the Christmas break, that ESY is not limited to summer. It is looking at those breaks and looking at how that's impacting your students' goals, where they are, if they're regressing and not recouping those skills, if they're at a point where that skill is emerging and they need to keep going because it's a key point in the development of that skill, whatever that goal is about, or if the severity or nature of their disability based on that goal still requires that those services be extended. This is not just limited to summer, though. Next, we're going to talk about non-academic services and program options, and these are sections 300.107 and 300.110. For non-academic services, what the federal law says, what IDEA says, is that each public agency must provide supplementary aids and services determined appropriate and necessary by the child's IEP team to provide non-academic and extracurricular activities for the child with a disability to have equal participation in those services and activities. When we're thinking about these non-academic and extracurricular activities, we could be thinking of counseling services, athletics, all those sports teams in our middle schools and high schools, transportation, health services, recreational activities, groups or clubs that are sponsored by the school, thinking of theater club and yearbook club, the school newspaper. This could be referrals to agencies that provide assistance and employment of students. These could all be examples of non-academic services. Talking about program options, the state must ensure that each public agency takes steps to ensure that its children with disabilities have available to them the variety of educational programs and services available to non-disabled children in the same area served by the agency. That includes art, music, industrial arts, consumer and homemaking education, and vocational education. So basically what this means is that you cannot limit the educational programs. You can't have less offerings for students with disabilities than what is currently offered to all students. And this is a bunch of other requirements that are included in FAPE regulation in IDEA. Methods and payments, the really important thing for families to know is that special education supports and services are free. They're at no cost to families. There is more information on what that looks like on the back end. I think the important thing for us to know as family members is that there's no cost to us. Child find. The state must have in effect policies and procedures to make sure that all children with disabilities residing in the state, including children with disabilities who are homeless or wards of the state or attending private school, no matter the severity of the disability, if they're in need of special education and related services, child find means they need to be identified, located, and evaluated. There needs to be a practical method developed and implemented to determine which children are currently receiving special education and related services. The physical education requirement on the federal law is that all children receiving FAPE must have physical education available to them unless the school doesn't offer PE to children with disabilities in the same grade. Each child with a disability must be given the chance to participate in regular PE, the same PE as provided to non-disabled students, unless the child is enrolled full-time in a separate facility or needs specially designed PE as prescribed in the IEP. So if a special program is needed, it must be provided by the school. If a special program is not needed, each child with a disability must have the chance to participate in regular PE, the same one that's provided to non-disabled students. The full educational opportunity goal is that the state must have in effect policies and procedures to demonstrate that the state has established a goal of providing full educational opportunity to all children with disabilities, and they have to have a detailed timetable for how they're going to accomplish that goal. Residential placement, if placement is in a public or private residential program, is necessary to provide special education and related services to a child with a disability. The program, including non-medical care and room and board, must be at no cost to the parents of the child. So these are the requirements of FAPE in the federal law. Also, routine checks of hearing aids and external components of medical devices. These are not optional. These are things that our schools have to do throughout the country to provide a free, appropriate public education. So that's a good overview of what is required by the federal law for FAPE. Let's talk a little bit about what's not required. I think it's really tricky that as parents, our goal is to help our children reach their full potential. And we have a lot of ideas of what may help, and we want the best for our kids. It is important to remember that FAPE does not require that services are superior to what other students receive. It doesn't entitle our students with disabilities to better services than what's provided in the school in general. Programming based only on parent requests, such as supports and services their child will receive, are not required. That these decisions are made by the IEP team, which does include the parent, but the parent does not have unilateral decision making. Our students also don't get preferred treatment in belonging to clubs or playing sports, but they are entitled to the same opportunity as every other student to be involved. So we need to make sure they have access, but if everyone is trying out for basketball, that doesn't mean our student with a disability automatically gets to be on the team. That means my child with a disability can have their supports and services with them in tryouts. And maybe they have a guide to the plays that they have on their wrist, or maybe they have a sign language interpreter that's giving them the directions at the same spot as the coach where they can look and get that information. They have the same opportunity to be involved. Those hurdles are removed. We make sure that those everyone has access, but they don't get preferred treatment to belong to the clubs or play the sports. So if there's a tryout, students with disabilities are still trying out with their supports and services in place. So that's a good overview of the requirements of FAPE in IDEA. Let's take a look at a couple examples and see if FAPE is being provided. Gianna is a 4th grade student diagnosed to be on the autism spectrum by her doctor. She is also eligible under ASD for special education. Based on her autism, the school places Gianna in the ASD classroom in the district. Gianna's goals were set by the classroom targets. The current classroom has students in 3rd, 4th, and 5th grade. Gianna will be in this room until middle school. At that point, school staff have decided she will move to the ASD middle school program. There's a couple of different things that stand out to me in this situation being described about Gianna. Number one is that FAPE needs to be developed to meet the student's unique needs and to provide an educational benefit for that one human being, that one student. So we don't want her goals set by the classroom targets. That is not the intention of FAPE. That is not a free, appropriate public education. It needs to be appropriate for her. We're going to talk more about placement in a couple of minutes, but placement is not decided once and then set. It must be determined annually, and the parent has a voice on that team. So in the 4th grade, we do not know what Gianna's placement is going to be when she's moving on to middle school in 6th grade. That is not a free, appropriate public education. There are a number of issues here in Gianna's situation that are not providing FAPE. Let's take a look at another example. Let's look at Jacob. And the question is still, is FAPE being provided? So Jacob is 20 years old with a cognitive impairment eligibility for special education. Jacob exited high school with a certificate of completion. He attends an adult transition program at his intermediate school district. This program includes job exploration in his areas of interest, independent living skill development based on a current inventory of Jacob's skills and future living preferences, and a reading goal because Jacob loves to read and would like to continue to develop this skill. What's being described here is tailored to Jacob. His strengths, interests, preferences, and needs are the basis for his plan. It is appropriate for him. This is a free, appropriate public education that's being described. Around the state, we often hear families are told that they can't have academic goals after high school, and that is not the case. There's nothing that states you can't have academic goals after high school. The goals need to be individualized to the person. We also hear a lot about young adults who are only doing job exploration and cleaning and food prep. The exploration may start with universal job skills, but it should be individualized to the one person's interests to provide a free, appropriate public education. You came today to learn more about FAPE in the LRE, and I hope we have a good understanding of what free, appropriate public education means and what that looks like at this point. Let's talk more about the least restrictive environment, LRE. LRE means your child should be educated to the maximum extent appropriate in the regular education environment with peers that are not disabled. Students should be spending time outside the general education classroom only if it's needed to meet the child's specific needs. LRE decisions are based on the child. They are not based on the convenience at the school or the staff. Federal regulations state that each public agency must ensure that to the maximum extent appropriate for that human being for their needs, the child with disabilities is educated with children who are non-disabled, and this needs to be a student-specific decision. It is not based on eligibility category. That does not determine what the least restrictive environment is. We need to be looking at that one individual child, and all children are general education students first, and then we can take a look at the least restrictive environment continuum if more supports are needed. So again, I want to make sure you have the actual wording of what's in the federal law, what's in IDEA. And that is that each public agency must ensure that to the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are non-disabled, and that special classes, separate schooling, or other removal of children with disabilities from the regular educational environment occurs only if the nature or severity of the disability is such that the education in irregular classes with the use of supplementary aids and services cannot be achieved satisfactorily. That means the student has been given an opportunity to participate in the general education environment, and even with supplementary aids and services, the student was not able to make progress in the general education curriculum and IEP goals due to the nature or severity of the disability. That does not default to a separate classroom. Specifically in the federal law, special classes, separate schooling, or other removal are only used if the nature or severity of the disability is such that regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. LRE has been a part of our federal special education laws since its inception in 1975. This is not a new idea. This is not something that just started. This is not something that Stephanie wishes for. Um, I do wish for this, and it is part of what is required in the federal law. So students must be placed in the regular educational environment to the maximum extent appropriate to receive supports and services as determined by the Individualized Education Program team. Remember, parents, you're part of the IEP team. When we're talking about regular educational environment, that encompasses regular classrooms, that encompasses lunchrooms and playgrounds, that the settings around the school where children with disabilities participate are many and varied, and all of those different settings are considered the regular educational environment. When we're thinking about LRE, when we're thinking about that least restrictive environment for our students that receive special education supports and services, because special education is not a place, I also want us to be thinking about this concept of least dangerous assumption. This was a theory that was developed in the early 1980s. I think in 1984, Donnellan is quoted as saying the criterion for the least dangerous assumption holds that in the absence of conclusive data, educational decisions ought to be based on assumptions that, if incorrect, will have the least dangerous effect on the likelihood that students will be able to function independently as adults. So we want to presume competence because presuming competence is the least dangerous assumption. It is the assumption that will not be a detriment to our kids. Um, One of the current researchers involved in this area is Dr. Jorgensen, and Jorgensen outlined 5 reasons for presuming competence as the least dangerous assumption. Um, One is that human intelligence is multifaceted. 2 is that measuring intelligence is flawed. We're not good at that. We don't know how to do it. There may not be a way to do it. C is that communication and high quality instruction are needed before we can determine capability. 4 is presuming incompetence could be harmful. And 5 is even if we're wrong, the consequence is not as harmful as the alternative. So even if we're wrong about presuming the student's ability to learn and to communicate in ways that are on par with his or her classmates without disabilities, being wrong about that isn't as dangerous as the alternative. In IDEA, Section 300.116D states that in selecting the least restrictive environment, consideration is given to any potential harmful effect on the child or on the quality of services that he or she needs. This needs to be an impact that we, again, want to think about those harmful effects. And we want to work from the least dangerous assumption. When we're thinking of harmful effects, we could be thinking of transportation times or the inability to participate in athletic programming if we're in a separate building, the impact on socialization with general education peers, thinking about having peer models to learn from. And documentation of those potential harmful effects is important when we're selecting the least restrictive environment. There has been a lot of research and there's a lot of data out there on inclusive classrooms. This is just a quick sampling of information, but students with significant cognitive disabilities who are educated in inclusive settings achieve greater success in academic outcomes, social skills, communication, peer engagement, positive behavior, and post-secondary outcomes. When students with disabilities are educated in inclusive classrooms, they develop skills like empathy and advocacy, and there's no negative effect on their academic performance. That we see students rise up in inclusive classrooms and build these additional skills. These are all factors that we're thinking about when we're thinking about educational placement. Educational placement is the setting where your child receives his or her education and services. Educational placement options like special classes, local programs, or center programs may only be used when your child is not able to make satisfactory progress towards his or her individualized education program goals in the regular education environment with special education supports and services. We talked about what the general education setting is. When we're thinking of the least restrictive environment, we want to think about where your child would go if they didn't need special education supports and services. What's the neighborhood school? What class would he or she be in that school? What activities would he or she do? What would they participate in? These types of questions can really identify the most appropriate education setting. General education, sometimes called regular education settings, we already talked about. They include classrooms, lunchrooms, playgrounds, libraries, any location where children without disabilities are being educated. Unless it's otherwise noted in the IEP, this is where your child should be educated. This is going to be the least restrictive environment for everyone, and if more support is needed, that's when we're going to start to look at the continuum. So placement is decided by a group of persons that includes the parents and other persons knowledgeable about the child. It isn't necessarily the IEP team, but it often is. And the placement decision is made based on the least restrictive environment provisions that are defined in IDEA. The child's placement has to be determined at least annually and has to be based on the child's IEP and as close to the child's home as possible. Unless the IEP of a child with a disability requires some other arrangement, the child should be educated in the school that they would attend if they were not disabled. And we need to consider those potential harmful effects we were just talking about. Children also cannot be removed from a regular classroom solely because of the need for modifications in the general education curriculum. That cannot be the reason. More supports, more modifications cannot be the reason to remove a child from a regular classroom. There are findings that were included in the most recent version of IDEA that in almost 30 years of research and experience, it's demonstrated the education of children with disabilities can be more effective by having high expectations for such children and ensuring their access to the general education curriculum in the regular classroom to the maximum extent possible in order to meet developmental goals and to the maximum extent possible the challenging expectations that have been established for all children, and for them to be prepared to lead productive and independent lives to the maximum extent possible. This is an area where we as parents can have a lot of impact. High parent expectation has been proven to lead to better outcomes for our kids. If we expect our kids to participate in the general education classroom, they're more likely to be in the general education classroom. If we expect our kids to have jobs, they're more likely to have jobs. That this is part of the federal law. These findings are included in IDEA because we have seen that this is more effective. The federal law, IDEA, does define that each public agency, which means school district in this case, must ensure that a continuum of alternative placements is available to meet the needs of children with disabilities for special education and related services. When a student is not able to participate in general education satisfactorily with supplementary aids and services, and they need a program placement that the district does not have, the district cannot be restricted to programs and services they currently have available. So the district may need to consider partnering with another district when a student is in need of a program or service that the district doesn't have. Let's take a look at Michigan's continuum of services. This is the LRE continuum that was developed by the Michigan Department of Education Office of Special Education. And this continuum of placement is from the least restrictive environment at the bottom to the most restrictive at the top. Placement options are considered, again, when your child is not able to make satisfactory progress towards his or her individualized education program goals and the general education curriculum in the regular educational environment with supplementary aids and services. So let's break this down a little bit. This starts with regular classroom and then looks at regular classroom with consultation. So the student is taught in the regular classroom by the classroom teacher who is advised by the special education teacher, by a special educator. And that may be to provide accommodations or modifications. Those services may be in place in that classroom. The regular classroom with supplementary instruction and services. Students still taught in the general education classroom, and it could be by both the classroom teacher and a special educator who are in that classroom. Next on this ladder, next in these steps, is the resource program, and that's where the student is in the general education regular classroom most of the time, but spend some of the time receiving specialized instruction in a resource room. Thinking of the separate classroom, next is a student attends a regular school, but they're taught by a special education teacher in a separate classroom. Next is separate school, where we're going to a different building. It's a special school designed for students with disabilities. A residential school is a student facility where the student lives 24 hours a day, it's a 24-hour care facility. Or homebound or hospital, the student receives special education services at home or in a hospital program. So the continuum means that these options are slightly different from each other. Some of the options can blend into others, like the changes of the season in a continuum. So spring blends into summer and summer blends into fall, but each is a different season. I want you to keep that blending in mind when we're looking at the lower part of this continuum. A child could be in a separate classroom for part of the day and a regular classroom with supplementary instruction and services part of the day. That it's not all or nothing for all of these options, but some of these options aren't all or nothing. So it's important to note that some cannot blend. So homebound or hospital placement can't blend. You can't have homebound services and um, regular classroom with consultation. It's also important to note that a district may have 2 or more equally appropriate locations that meet the student's special education and related services needs, um, that they're kind of tied for what the least restrictive environment is, and that the school administrator has the flexibility um, to determine the particular school or classroom, provided that that determination is consistent with the decision of the group determining placement. Remember when we were talking about placement, the placement decision is made by a group of persons, including the parents and others knowledgeable about the child, and is based on the IEP. So while it's not required that the IEP team makes the placement decision, they are the team that develops the IEP, and I think it's important that we take a look at who is on that team. So when we're looking at the IEP team, it needs to include the parents of the child, a regular education teacher if the child spends any time in a regular education environment, a special education teacher of the child, someone from the public agency, which is usually the school district, who is qualified to provide or supervise specially designed instruction to meet the unique needs of children with disabilities, someone who is knowledgeable about the general education curriculum, and someone who is knowledgeable about the availability of resources within the school district, within the public agency. There also needs to be an individual who can interpret evaluation data, and at the discretion of the parent or the agency, other individuals who have knowledge of or special expertise about the child. That could be related service personnel, that could be other relatives, that could be who the parent or school district thinks is appropriate to include. And whenever appropriate, we should be including the child who we're meeting about, who the plan is for. I think it's important to know that one person can wear multiple hats in these roles. So someone has to fill all of these roles, but this could still be a 3-person meeting. This could still be a small meeting as long as someone is able to fulfill all of these roles. So when you're in a meeting and there is you and the regular education teacher and the special education teacher, as long as one of those teachers um, is qualified to provide and supervise specially designed instruction, one of them has knowledge about the general education curriculum, one of them can allot resources from the school district, knows what's available, somebody can interpret data. As long as we have all those roles, it can be someone wearing multiple hats. The IEP team should work together towards general agreement, but decisions are not majority rule. The goal is consensus. At the end of the day, the public agency is ultimately responsible for ensuring that a child receives FAPE, that the child receives their free appropriate public education. It is not appropriate to make IEP decisions a majority vote, that we want to reach consensus. If an agreement cannot be reached, then the public agency makes the determination and provides parents with prior written notice. And prior written notice includes information about their procedural safeguards and how to disagree with that decision. That prior written notice is required about placement before the IEP becomes effective. And it has to include these 5 requirements. It has to have a description of the action that the school district proposes or refuses to take, an explanation of why the school district is proposing or refusing to take that action, a description of evaluation, assessment, records, um, how the school district decided basically, how they decided to propose or refuse the action, a description of any other choices that the team considered and the reason why those were rejected, and a description of other reasons why the school district proposed or refused the action. Again, all of this information does need to be shared prior to the IEP becoming effective. Let's take a look at a couple of examples and think about free appropriate public education in the least restrictive environment. So our first student is Mateo. Mateo is a middle school student with emotional impairment eligibility. He receives most of his instruction in a self-contained classroom. He participates alongside his peers without disabilities at lunch, PE, and swim team practice. Let's think about what questions we have if we are a member of Mateo's IEP team. What we're thinking about when we're thinking about his placement and if it is the least restrictive environment. He's currently in a separate classroom. Um, we want to know what the needs are of Mateo. Why was that placement selected? What other options were considered? Was he previously making progress in a general education classroom? When was that? What did that look like? If not, were supplementary aids and services provided to Mateo sufficient to support his unique needs and to provide him access to special education? We also want to be thinking about progress moving forward. What skills are being developed now to be successful in the future in a less restrictive environment, to be successful in a general education classroom? As a parent, I might be thinking my child was included in the past and it didn't work. Why would we want to try again? And I think that's an important conversation to have with the team about what the appropriate supports would be and how to make sure things that were problems in the past would not be problems again, and how to be continually looking at what the least restrictive environment is for the student. Let's take a look at another placement. Let's look at Luna. Luna is a fifth grader with low vision eligibility for special education under visual impairment. She receives her instruction in the regular education classroom with accommodations of braille materials, preferred seating, and a screen reader. So services are provided by the general education teacher with accommodations and modifications as needed, and instruction is supported with specialized materials, equipment, or instruction methods. Again, we want to think about, as a member of this team, what questions do you have? We always want to be starting with what are the needs of the student? What supplementary aids and services does the student need? Who makes sure that those supports are in place? And how will the team support a smooth transition to middle school? There's going to be new challenges next year with changing classes, with a new building. What does that look like? Harper is in a regular classroom with supplementary instruction and services and resource program. So Harper is a 10th grade student with ADHD who is eligible under other health impairment, OHI. She spends her day in the regular education classrooms throughout the building. A special education teacher periodically comes to the classrooms to observe and provide support. The special education teacher works with the regular education teachers to provide class notes and assignments broken down in steps for Harper. And Harper also has resource program one class period daily to organize her work from her other class periods and provide additional instruction. So most, if not all, of the instruction is provided by the general education teacher with accommodations or modifications as needed. The services are provided by the special education teacher to consult with those teachers and collaborate with the general education teachers to plan and provide for instruction that's appropriate for Harper. And then she has individualized or small group instruction based on her individual needs. So if you're a member of this IEP team, what are your questions? What do we want to make sure we're thinking about when we're thinking about least restrictive environment? Again, we always want to start with what are the student needs. That needs to be the individualized education program to be an appropriate plan to be providing FAPE needs to be centered around the student and the student's needs. What supplementary aids and services does the student need? Are the supports and services consistently provided in all classes? This is something that gets really challenging when we're in middle school and high school. Have lots of teachers involved making sure that those supports are consistent throughout the day and that Harper's getting what she needs. When are the teachers able to connect and plan and develop those needed supports? Is there time within the week, the month? How are they doing that? Is that electronic? Is that in person? What does it look like? And then how does the resource program teacher know what happened in the other classes to be able to help Harper with her organizational strategies or the work that needs to be completed in those other courses? How is that communication taking place? These are things as a team we want to consider to be able to provide Harper what she needs. Leo is our last example of placement. He is in a separate school. So Leo is a second grade student. He is deaf and eligible under deaf and hard of hearing. After a detailed discussion about less restrictive environments, his IEP team, including his parents, decided Michigan School for the Deaf currently best meets his needs. So he receives the majority of his school day in a separate facility, and the services are provided by that school. It's designed, staffed, and resourced to care for the education of students with similar disability-related needs. So it's a specialized education. In Michigan, the Michigan School for the Deaf is a public residential school in Flint for students who are deaf or hard of hearing and was established by the Michigan legislature back in 1848. Students refer to the school by their local school district, and placement is determined by an IEP team. So students who attend Michigan School for the Deaf receive a unique combination of services and intense exposure to two languages, both American Sign Language and English, as well as academic and residential services. So it's very intensive to meet the unique needs of the student. If you are on this IEP team, what are those questions? What are you thinking about? Always we're thinking about what are the needs of the student? What supplementary aids and services does the student need? The child is in a segregated school. How do we start making steps back into his home district? What skills or behavior are being taught that will allow Leo to participate in academic, non-academic, and extracurriculars with non-disabled peers? Also, it's important that schools consider, IEP teams consider for a child who is deaf, communication needs and the needs of the family's preferred mode of communication, what those academic needs are, just as a placement in a regular education setting is required when it's appropriate for the unique needs of a child. For a child that is deaf, so is removal from the regular education setting required when the child's needs can't be met in the setting with the use of supplementary aids and services. Hopefully those examples clarify what some examples of a least restrictive environment could be. I also want you to remember that least restrictive environment, LRE, extends beyond the classroom. That we as parents often start by focusing on how our kids learn in the classroom at school. When we're talking about least restrictive environment, we also want to be thinking about those non-academic times. We want to think about lunch and recess and passing time and extracurricular activities. That IDEA requires your school ensure that your child participate in these activities to the maximum extent appropriate. That's what's appropriate based on the needs of your child. It also requires the school provide supplementary aids and services for your child to participate in those settings. So to really think about what that might look like, let's talk a little bit about what is a supplementary aid or service. Supplementary aids and services means aids, services, and other supports that are provided in regular education classroom, other education related settings, extracurricular, and non-academic settings to enable children with disabilities to be educated with non-disabled children to the maximum extent appropriate. So these are supports that can go to any of those educational environments to provide access. Let's take a look at a couple of examples of what these might look like. What might those additional aids and services look like during non-academic times? Let's think of a student who struggles with behavior during unstructured times. Maybe there are problem behaviors at recess. If that is the case, what additional supports could be in place to help the student at recess? What needs to be there? Is there a social skills plan? Is the social worker involved? Is there a peer buddy? What is going on to provide some structure and some guidance during recess? If we're seeing problem behaviors, have we done a functional behavior analysis and looked at what the root of the behavior is? Have we developed a behavior intervention plan that we're supporting during recess, that we're providing that's individualized to that one human being? And if those were words that felt foreign, that we have behavior questions, but we don't know what functional behavior analysis or behavior intervention plan are, I encourage you to check out our PBIS video or to look on our website for FBA or BIP. That there is lots more information when we're looking at those problem behaviors and how we start to address those. Thinking of extracurricular activities, we talked about sports having tryouts. We talked about, just like all students, a child with an IEP would have to make the team in order to participate. It's important that they have the right to try out with the needed supports. They have the right to be treated fairly in the judging and to get supports on the team if they're chosen to be on the team. So let's say a child with a disability that impacts their memory and sensory needs some supports. We could be thinking about noise canceling headphones in the loud gym. We could be thinking about fidgets on the bench when not playing, or a wearable play guide to reference the play if memory is a factor. So there's all sorts of different aids and services that might make sense to support our kids in their extracurricular activities. These still need to be tailored to the individual child. Let's take a glance at one more example. Perhaps a teenager with a specific learning disability in reading is interested in being a part of the school play. When they try out, they get a part. They also need the audiobook of the play in addition to the written text. And they may need the blocking of the character to be provided on a map instead of in a written description. So we can get those verbal directions, we can get those visual directions, we can do those things in different ways to meet the unique needs of the child. Within the federal law, within IDEA, it talks about the requirements for technical assistance and training and monitoring activities. In Michigan, the Michigan Department of Education is the state education agency. And IDEA states that they must ensure teachers and administrators understand their responsibilities and are provided training and assistance. MDE also monitors that LRE requirements are met and implemented. If MDE has evidence that your school is not following LRE requirements, and we'll explore more of how they might find evidence and talk more about dispute resolution options in just a moment. But if they have evidence that they're not following LRE requirements, they must review the explanation for the decision and assist in planning and implementing the needed corrective action. IDEA does define dispute resolution options, that we have rights if we don't agree with the decision of the school. And that's part of why prior written notice is provided, so that we know more about our rights and we have that documentation also. So talking through some of these options, let's start with the least formal, closest to the student. That's going to be informal meetings. That could start with you talking to the person you have a disagreement with. If you are have a disagreement with the general education teacher, you're talking to the general education teacher. If we're not able to reach an agreement there, you may be bringing in your case manager, your IEP coordinator, your main contact person for the IEP. Having those conversations, documenting the issues and the proposed solutions that you're talking about so everyone can keep track of it. If you're not able to reach resolution there, you may climb the internal ladder within the school. You may talk to the building principal or the special education supervisor, special education director, regional special education supervisor, ISD special education supervisor at your intermediate school district. Each ISD also has an ISD representative whose job includes investigating complaints. So they can be a contact point as well for having these informal meetings when you're climbing that internal ladder and trying to reach resolution. Sometimes we need something that's a little more structured, but still at that same level where we're talking to the people that interact with our kids all the time. So we could have a review of the IEP. So it's a more formal meeting to resolve the disagreement. It's bringing the team together to discuss and decide on changes to the IEP. The purpose would be to review the existing document and determine if it's currently written to ensure success and meet the student's needs, and to make those adjustments that are needed to meet the student's needs. There's also an option to have a facilitator come to any structured special education meeting, including an IEP meeting. This is really great if you feel like communication is breaking down, if you don't feel like you're being listened to, that it's an impartial third party that comes to that structured meeting. They are a neutral facilitator. They don't represent you. They don't represent the school. And everyone has to agree for them to attend. It's voluntary. Special Education Mediation Services does provide this service for free across the state to help you work out your differences. So they could come to an IEP, an IFSP, a behavior plan, a manifestation determination review, any of those structured special education meetings. Special Education Mediation Services also provides mediation, which is different than facilitation. It's not that structured special education meeting. It's a meeting specifically to resolve disagreements. So it's specifically for disputes related to special education and early intervention services. SEMS can schedule the meeting. They can find a mutually agreed upon time. They can contact all the parties that need to be involved. In these meetings, the neutral mediator guides the participants, who may be different from the IEP team members, to identify options and evaluate the options to meet the student's educational needs. All of the conversations in mediation are confidential. They can't be used in other court proceedings, and the agreement is legally enforceable if there is an agreement reached. Again, mediation is voluntary for the school and the family to participate in. So they have to agree to participate. They can basically opt out is an option. They can say, no, we're not going to do that. You can say, no, I'm not going to do that. There are also more formal complaint options, and if you think your rights have been violated or that the law is not being followed, you have the right to file a state complaint or a due process complaint with the Michigan Department of Education. And this is one of the ways that MDE might discover evidence that your school is not following LRE requirements. I just mentioned that they have a responsibility for monitoring. If they discover evidence, there has to be a corrective action plan issued. This is how they might discover the evidence, is through the complaint process. Let's take a closer look at the state complaint and the due process complaint. I do think it's important to note you don't have to do these in any specific order, but the closer to your child you can solve the problem, the faster, the cheaper, all of those things are factors. So having those informal meetings is typically the best starting point to keep a collaborative team working together to meet your students' needs. So a state complaint has to be in writing, and it's submitted to the Michigan Department of Education Office of Special Education. They do have a form that you can find on their website. You don't have to use their form, but using their form can help you make sure you have all the required information, and it can help you be prepared and organized for meetings and discussions. It just kind of helps you get your thoughts in order, get your concerns, your documentation ready. Our regional parent mentors cannot write a complaint for you, but they can support you through the process of writing and submitting your complaint. When you do submit the written complaint to the Michigan Department of Education Office of Special Education, you're alleging that the school district has violated a state or federal special education rule or regulation, or has failed to implement an intermediate school district plan about how special education services will be provided in the district, or failed to implement a due process decision ordered by an administrative law judge. So really what the complaint investigator is going to look at is if the district was compliant or not compliant with one of those special education rules and regulations. They will investigate typically from a distance, and the final decision is issued within 60 days. If the district is found non-compliant, Then they're going to write themselves a corrective action plan to resolve the compliance issue and submit that to the Michigan Department of Education Office of Special Education. And then the school district is going to provide documentation that the corrective action plan is being completed. State complaints can be for issues about FAPE, like what we're talking about today, that we are not getting a free appropriate public education, that the IEP is not being implemented with fidelity, that it's not happening across the board, that what has been offered as free appropriate public education in the individualized education program is not being completed as written. Those could be reasons for filing a state complaint. The most formal process is a due process complaint. This also starts as a written complaint filed with the Michigan Department of Education Office of Special Education. They refer it on to the Michigan Administrative Hearing System, and an administrative law judge, often referred to as an ALJ, is assigned. There is a required resolution meeting unless the parent and the school district agree to waive it. The ALJ will have a hearing very similar to a court hearing where you have witnesses testifying under oath, they're cross-examined, there's evidence and exhibits and documents, there's opening and closing statements. The school district will be represented by their lawyer, and parents should consider at least consulting with a lawyer to get an opinion on the merits of their complaint prior to filing the complaint. Due process complaints address issues related to identification, eligibility, evaluation, placement, FAPE, and they can be an appeal of manifestation determination reviews. The administrative law judge issues a written decision and an order, and you may or may not agree with the ALJ decision. The school district also may or may not like the ALJ decision, but know that the Department of Education, Office of Special Education, is going to enforce that ALJ decision. With a regular due process hearing, the decision and order is issued 45 calendar days following the resolution session. Thank you for taking time out of your day to learn more about FAPE and the LRE with me. These are key concepts in our special education law and can dramatically change how we see our kids' special education supports and services. In the words of Maya Angelou, do the best you can until you know better. When you know better, do better. We're glad to share the information with you. Remember, our regional parent mentors are here to help you do better. That's what we do. That's what we're here for. If you have questions, please go ahead and reach out to your regional parent mentor to contact them directly. Follow us on Facebook, Twitter, Instagram. Check out the YouTube channel for more videos. And we hope this information was helpful. Have a great day. Michigan Alliance for Families is an IDEA grant-funded initiative of the Michigan Department of Education, Office of Special Education, and Michigan's Federal Parent Training and Information Center, funded by the U.S. Department of Education, Office of Special Education Programs.